Pardon me, it seems we have both counsel present before us. Mr. Swords, uh, I believe you represent the appellant in this case. Am I correct?
Yes, Your Honor.
Did you wish to reserve any time for rebuttal?
Yes, Your Honor. I will reserve 5 minutes.
I will do my best to promptly notify you when you arrive at that point of your presentation. With that, you may begin, counsel.
Thank you very much, Your Honors. And as the court is aware, this case has some overlap with the previous case that you just heard. And so I will try to not be redundant of Citizens' position in that case, although there necessarily may be some. And my name is Daniel Schwartz. I apologize. May it please the court. And as the court knows, though, what is different about our case and really makes this an ideal vehicle for the court to hopefully write on this structural damage issue is that Citizens stipulated to the fact that sinkhole activity was present at the property and caused the damage. So we got rid of all of the noise, all of the stuff on the sides as to how this loss occurred. All that was left in the case is when did the damage occur and was it structural? And we had a concerted plan to set the record up this way because we knew we would eventually be here on this very important burden issue following the definitional change with its related change to the insuring agreement that was just discussed in the previous case.
Mr. Schwartz, I appreciate your setting out what you think are the differences in the two cases, but in terms of our analysis, is there really any difference as far as if we agree that Mejia and the other cases basically say all peril policy, all the plaintiff has to do is show damage, and then it becomes an analysis of the exclusion within the all perils policy because it has an exclusion for sinkhole damage, and then the case law is treating the exclusion or the addendum or the endorsement for sinkhole as just expanding or further defining what would be an exclusion. So do the two cases really differ?
The only thing I would say about how they may differ in that important respect is the pleadings. In the previous case, the plaintiff deliberately pled that there was only physical damage to the property in the interest of trying to fit this into the what we contend is a square peg round hole situation. Whereas in our case, the plaintiff actually pled we have sinkhole loss and we have structural damage. So that is one difference the court may find to be significant because that immediate, if you look, and I think in the last case, there was reference to judge concurrence in Mejia. I believe Ms. Ender and I had spoken, Judge Aldenburn's concurrence in the Salke decision is also important as well, where he refers to this as a hybrid and in part a named peril issue. And so, in other words, the plaintiff pleading that they have sinkhole loss and that they have structural damage takes us immediately to the sinkhole endorsement. And as Ms. Ender said, requires them to prove coverage that's within the threshold insuring agreement. And because this is undisputedly a sinkhole loss from the very outset of the claim as it's pled, that is one distinction. But to go back as well, Judge Silberman, I respectfully disagree that Mejia and the subsequent cases treat structural damage as an exclusion, as Your Honor framed it. The fact is it is not an exclusion, and my opponent has said, in order to try to fit it into that categorization, my opponent has said sinkhole activity without structural damage is an exclusion. And that requires a rewriting of the insurance contract. There's simply no reading of the insurance contract to call sinkhole activity without structural damage an exclusion. So we're just trying to overlay this Mejia framework of prove direct physical loss, the burden shifts to prove an exclusion over a formulation in the insuring agreement whereby sinkhole loss requires structural damage as now defined as something that it's fundamentally different here. So and you know, I would direct the court as well to our the burden of proof instruction, which goes to the same ideas at page 2522 of the record, and it characterizes structural damage as an affirmative defense. Similar to it not being an exclusion, it is not an affirmative defense because that insuring language in the endorsement says we cover direct physical loss caused by a sinkhole loss, which then includes structural damage. And so the problem with that, and one thing that didn't come up in the previous case, is even though structural damage as a term was part of the statute since 2005, the courts had defined it as no different than physical damage because the courts defined it as damage to the structure. So legally, there became no difference in the quantum of proof between physical damage and structural damage until the definitions changed. And so I think the burden, the general all-risk formula of Mejia and Munoz, it's trying to craft a fair procedure when for the dispute as to causation. But that's irrelevant when sinkhole loss is at issue, and as here, sinkhole loss and structural damage have been pled, which supports the conclusion that those are things the plaintiff has to prove. So
let's talk about that just for one moment longer. The plaintiff introduced evidence of structural damage meeting the statutory definition through an expert, correct?
correct.
So it's not a problem of pleading one thing and then failing to present evidence to support that thing. It still goes back to ultimately the jury instruction as far as who has to prove what and who has what burden, correct? Because I don't really see this as a pleading issue. I don't even see it as an evidentiary issue because they did present proof of structural damage under the statute. So it goes back to sort of the Mejia analysis, is it correct or incorrect? And the other line of cases which reiterate that for an all-risk policy, we are treating these types of sinkhole claims as, and the definition of what is a sinkhole claim, as an evidentiary burden for the insurance company to prove, nope, it's not covered.
I agree in the sense that to reverse in this case, the court certainly needs to and should hold that Mejia and Munoz do not address, they involved an old statute. They did not genuinely analyze, although Mejia mentioned structural damage, it didn't analyze really that issue. It didn't really seem to feature on appeal. So I agree that you will need to hold that Mejia and Munoz do not apply, or just do not address the issue in this case following the statute changing, and therefore the fundamental insuring agreement in the case of a sinkhole loss also changing. But also to your point, I wanted to address the verdict form because it goes to your mention of jury instructions. And I really think the verdict form illustrates the problem here, because question 1 on the verdict form was, did plaintiff prove the direct physical loss? And the jury answered yes. So then the question 2 was, did citizens prove that it was not structural damage? So what happened in the middle of those two questions? Well, when the jury found it was physical damage, and then the burden being shifted to citizens to prove this, and then finding a double negative that Citizens did not prove structural damage, I believe that created a presumption that physical damage and structural damage are the same, but they are not the same. And in fact, that's exactly why the definitions changed to remedy the problem of the courts having defined structural damage as damage to the structure.
But
So-
you heard in the earlier case that this issue could have been resolved simply by a question, do you find that there was structural damage? And that question was not asked. And that might have solved everybody's problem, set aside the jury instruction language.
Yes, and if the court had given the verdict form we requested, do you find that there was structural damage during did plaintiff prove by the greater weight of the evidence there was structural damage during the policy period? We wouldn't have that problem. But
I guess I'm hanging on to Judge Altenburn's concurrence, where he talks about some of the problems with the policies and the statutes and so forth. And it just seems like if the instruction didn't say who proved what on that issue, do you find that there was structural damage? That might have cured the concerns. I'm not saying it would have, but it just, from an intellectual standpoint, that to me is an interesting issue, whether that would have cured the problem.
I think on the verdict form that we had, it might have been confusing if it was simply added as like a third question, because again, the jury was asked, did Citizens prove there was not structural damage? So it assumed that the physical damage was structural. So, I mean, yeah, the verdict form could have been, you know, written a different way, but as far as to the extent Your Honor's question goes to preservation, I don't think we have any issue with that here, because we are again, as I said at the beginning, in the interest of really trying to set this up and getting rid of everything else, our jury instructions clearly that we asked the court to give, although we know it was contrary to the burden of proof ruling, would have said, did plaintiff prove it during the policy period? And then our verdict form also would have said, did plaintiff prove it during the policy period? And that would give us the definitive yes or no, consistent with Your Honor's question. Whereas I think
if the legislature would have written the statute a little differently to address burden of proof, knowing that Mejia and other cases are out there, that would have at least made clear what is their intention in terms of how the legislation should apply. Now, I recognize that might leave open a separation of powers constitutional issue, but that has not precluded the legislature from trying to set out a policy in a manner that gives guidance. And then we reach the issue of constitutionally, does it withstand scrutiny?
Well, Your Honor certainly addressed my response that I was going to say, which is, you know, I don't think it's in any way unusual for the legislature to set out substantive changes and just leave it to the courts to fashion burdens of proof that.
You'd think there'd be some comment on it after 20 years of handling these cases a certain way. And I don't know that we, as a court body, can read more into the statute than what the actual wording of the statute says, or in this case doesn't say.
But I don't, respectfully, Your Honor, I don't think it's reading into the statute. I think, as Judge Altenburn said, whenever there's one of these changes, it falls to the courts to fashion a burden framework that best gives effect to the statutory scheme and the investment.
Judge Altenburn meandered around in that concurrence, to be sure, but one thing he did do is he began the concurrence with a full-throated endorsement of Mejia, and he ended the concurrence with a full-throated endorsement of Mejia.
Fair, Your Honor, but I think the concurrence is valuable in that it is a roadmap for the court to take a step back and ask what framework is now most compatible with the statutory scheme that we have. And it hasn't yet been done, other than arguably, as was touched upon, in a couple of PCAs, some of which may have involved the old statute, others which may have had records that was simply not to the court's liking. So, excuse me. So I don't think we should be looking to PCAs to say that the court has really looked at this or decided this since these changes.
Really not looking at the PCAs. I'm looking more at Munoz and Mejia, and I don't see any difference between the two and between the case we're now hearing.
Well, the
As you
difference,
frame your response, I'll let you know you just hit 15.
very well, Your Honor, thank you. Well, the difference, Judge Black, is that the legislature changed the definition to add these things that require analysis of structural soundness to the home and safety that are relied upon by architects and engineers, because the courts were defining structural damage as damage to the structure, which wasn't any different than physical damage. And nothing in Mejia and Munoz, in my opinion, says that structural damage is an exclusion, and that's not consistent with the way the policy is written when coverage is sought for a sinkhole loss. With that, I will I'll reserve the remainder. I don't know if the court would allow me to get into the other issue in rebuttal.
Well, I assume you're relying on your brief for everything.
Yeah,
So I would suggest that-
I'll just spend 1 minute just to go to issue 2, Judge, which is
okay.
That alternatively we are asking for a new trial because of the stipulation that I mentioned. We only should have been trying the case about structural damage. And however, plaintiff's counsel continually reminded the jury that it was a sinkhole loss. In other words, they obtained the benefit of us having stipulated to that issue by not having to present proof on it, but by also reminding the jury that this was a sinkhole case, which was, we submit, prejudicial and contrary to the court's in limine ruling that there wouldn't be evidence of sinkhole activity based on the stipulation. So with that, I'll yield the remainder of my time.
Thank you, counsel. Is it correct to say Bailey?
Yes, Your Honor.
Good, because I believe it was Mr. Swartz, right?
Schwartz.
There's no T. You
I do
pronounce it Swartz?
I do pronounce it Schwartz.
Okay. You would have got me in trouble in my law firm because one of my partners was Swartz with no T and didn't pronounce it Swartz. But thank you for making sure I pronounce it. You're welcome. Okay, Mr. Bailey, you may proceed.
Thank you. Good morning, Your Honors. May it please the court. Jeremy Bailey on behalf of the Appellees. I've had the benefit of listening to Your Honors discuss this issue for, I think, 40 minutes now. So I don't want to rehash anything or tread new ground. The two issues raised on appeal, I think the court should affirm in both respects. On the first issue, the burden issue, I think the court has aptly stated that the analysis begins and ends with this court's opinions in Hudson, Mejia, and Munoz. In each of these three cases, the analysis remains consistent that the insured has the burden to prove damage within the policy period. That's the insured's burden. And when we're talking about legislative intent to change something, to change the burden or change the standard, and fully appreciate the comments I've heard this morning from the panel that the legislature is not unaware of the opinions of this court or other courts on this issue. And there's nothing in the statute, there's nothing in the statutory language, which is where we find legislative intent, that alters that analysis. Mejia and Munoz are on all fours. The trial court addressed this issue.
Mr. Bailey, can you hear me?
Yes, Your Honor, can you hear me?
Mr. Bailey, you've lost sound. You're back. Yes, you're back now.
Mr. Bailey, I was going to ask you a question. Let's assume for the sake of argument that we accept the invitation of citizens to write on this issue. If we were to write an opinion that still affirms, what would we write as far as, clearly the burden to prove that the claimed property damage doesn't amount to covered damage, if we're to stay consistent with Mejia, would be that we remain consistent with Mejia. But what would we say as far as the plaintiff's burden in terms of evidence of damage? Is it simply enough to prove property damage, or do we have to say that they do have to present some evidence of structural damage? And if we say that, does that mean the burden of proof has shifted?
Your Honor, I think consistent with this court's prior precedent, it would have to say that the burden is just to prove damage within the policy period. And that, and Judge Alton Burns' concurrence in Mejia is right on point here, that what Citizens is really asking for is to convert the sinkhole coverage from a all-risk policy coverage into a named peril coverage where the plaintiff has the burden to prove that the damage is within the coverage. And that's simply not what the law or the policy provides. Citizens, and I know that Judge Altenberg got into some of the policy rationales, but there's nothing in the statutory language and the policy rationale support having the insurance company who bears all of the burdens under the statute to do the investigations, to get the reports, to go through all those analyses. It only makes sense that the insurer retains the burden to prove the excluded cause of loss, namely that the sinkhole damage or the damage was not structural damage. That's the crux of the insurance company's burden in all of these cases. That's what Mejia said, that's what Munoz said. To flip that burden would essentially require the plaintiff to not only prove their case, but to disprove the defendant's case from the get-go before the defendant ever had to call a first witness. And that's what's important here when my colleague talked about the changing of the verdict form. Their instruction would not be, like you suggested, Judge Silverman, just straight up, was there structural damage? It actually inverted the analysis. And so the plaintiff would bear all of the burden at trial. Did the plaintiff prove damage within the policy period? Did the plaintiff prove that there was structural damage? What would be left for the jury to be asked about the defendant? That's the questions. That's the analysis. So it would flip the burden of the case and require the plaintiff to prove everything, disprove the defenses that there was an excluded cause of loss, just to meet their burden at trial. And that's not what the policy says or what the case law holds.
What's interesting in both these cases is the insurance presented evidence of structural damage in both. And so you do have them carrying that burden to the extent there is any burden. And I understand it's because it's an all risks policy. It starts out as an all risk policy, but then there is an added coverage for something that's normally excluded from that policy. So as the opinions have reiterated over and over again, this is a strange bird.
Yes, Your Honor, and I would say as a practical matter at trial, I think as a function of making sure the jury hears both sides of the issue on structural damage is why the insurers would also introduce evidence on that point, right? I mean, if the insurers just presented evidence on damage and the insurance company was the only one who presented evidence on structural damage, it would leave the jury, thinking that the plaintiff, couldn't overcome the defendant's defense. But it's not taking on the mantle, so to speak, of saying that they're going to affirmatively disprove or bear the burden to prove that defense at trial. It's merely making sure the jury has the full picture of the loss. The second thing, and I'm happy to welcome any more questions about the burden. I know Your Honors have heard a lot of argument about that.
Mr. Bailey, let me add something that may be entirely irrelevant to this. If it is, please let me know. But while you gentlemen are an expert in this area, I'm a general practitioner. So we know that this policy is an all risk policy. And normally sinkhole would be excluded from coverage. Is that correct?
Yes, Your Honor.
So arguably then, the insurance company would have the ability to write a second policy, a named peril policy that would ensure only sinkhole coverage and would incorporate the various definitions that the legislature had, placing the burden then on the homeowner to prove coverage under that. Is that correct?
And just to make sure I heard the question, it was that they could do that, not that they did do
That's
that?
correct.
Yes, they
Correct.
could do that.
So the insurance company arguably understood what was going on and elected to write it as an endorsement, knowing the case law of all risk policy that's come out. Does that in any way impact our analysis, or is that so far tangential that we should leave it alone?
I think that's right on point, Your Honor. I mean, Citizens issues these policies every year to its insureds, right? And every year they issue a new policy. In the 10 years since Mejia and the 10 years since Munoz,
And when
that's
they
not
write an endorsement adding this coverage, they charge a premium, just as they would charge a premium for a named peril policy, right?
correct.
I don't know what the numbers would be, but conceptually that much is similar.
Correct, Your Honor. And they certainly could have done that way and have not. I want to just move briefly to the second issue on appeal, the evidentiary issues. We noted in our brief that there's a lack of preservation as to almost all of the evidentiary issues that were argued in the motion for new trial. In Mr. Diaz's testimony, he used the phrase sinkhole one time to merely express that he didn't make any prior repairs for sinkhole damage so that he could meet the defense that was coming, that there was that the loss occurred within the policy period. As to Ms. Root, the corporate representative, when trial counsel for Citizens was asked about reading it in, they stipulated, said there's no objection to reading it into the record, and then in their motion for new trial and on appeal say that it was prejudicial error. There's the alleged errors were largely unpreserved. The only one that was timely objected to was the Christman testimony, and that certainly didn't violate the orders on the eliminate motions from Judge Huey. So unless Your Honors have any further questions, we ask that this court affirm the final judgment in all respects. Thank you.
I don't see any questions. Thank you, counsel. Mr. Swartz, you have 4 minutes remaining. My screen shows you muted. You may want to address that first before you begin. Thank you.
Thank you, Your Honor. I will briefly address what I think was perhaps a overstatement with respect to the verdict in this particular case mentioned by Mr. Bailey. I think Mr. Bailey argued that if the verdict had been given that we requested, the defendant would have no burden. Well, yes, that is true, but there is absolutely nothing wrong with that in this particular case where we stipulated to sinkhole activity, and you know that in other words it was covered from the standpoint of causation. And so in other words, we were entitled to not have any affirmative defenses. Now that wouldn't, if we had not stipulated to sinkhole activity and we were contending that the damages were included by earth movement or wear and tear or improper construction, then that would have been our burden, but that wasn't the case here. So there's
And that
nothing.
would have been a burden by way of affirmative defense, an admission and an avoidance, or by coverage language, or both.
Both. If we had been contesting coverage on grounds of an excluded cause of loss, we would have had to plead that and prove it. But that's not the case with respect to structural damage. So there's nothing improper about plaintiff bearing the greater weight of the evidence burden, and then that ends the case. Now, with respect to the preservation on issue 2, we relied, as was mentioned in the first argument Your Honors heard today, on section 90.104 Florida statutes, which provides where there's a definitive ruling excluding evidence that further objections need not be made. And both the parties discussed the Boyles case out of the 4th DCA in their briefs. I have it up here, and the court specifically says where evidence excluded by a prior order in limine is admitted inadvertently simply because it was not pointed out to the trial court that the evidence violated the order. This provides an appealable issue and opportunity for a new trial, even though the error could have been easily corrected had it been pointed out. And so even if, and you know, so that is sufficient, having gotten those two rulings by Judge Nash before the trial began. Moreover, during Mr. Christman, sorry, I had an echo on my end. During the testimony of Mr. Christman, as counsel said, we did object to the question as to holes or depressions. The court sustained it, but it was really only a sustaining in part because he then went on to say you can ask questions as it relates to a rebuttal of a certain point about collapse. But then my trial counsel said, well, this still goes against Your Honor's order that we should not have evidence of sinkhole activity. And reversal on that issue would be consistent with the law enforcing pretrial stipulations, which we know are important. They're blueprints for the trial. They may even be considered the Bibles for a trial, and they provide a streamlined procedure that are binding on the parties and everybody should follow. If the court has no other questions, we will ask then that the court reverse, conclude that plaintiff should have borne the burden to prove structural damage pursuant to the insuring agreement, or alternatively reverse on the second issue and award citizens a new trial.
Thank you. Thank both counsel for their excellent presentation today and your preparation. We very much appreciate it. And with that, that will conclude our docket this morning, and we will let you transfer over to wherever it is that they say that you are transferring over to. Thank you and good day.
Thank you.